Imagine navigating one of life's really tough transitions. The painful decision to end a marriage. Where do you even begin?
Yeah.
For something so personal, the legal side of things can feel, well, incredibly daunting. Especially somewhere like India, where personal laws are so tangled up with religious identity.
It's true. Divorce isn't just a legal thing. It's huge, life-changing. And having some clarity about how the law works is just essential to finding a way through it all.
Exactly. So our mission today is to take a deep dive into that legal framework for divorce in India. We're looking at the key insights from Advocate Abhishek Jat's article, Divorce in India, Grounds and Procedure. Our goal is to give you a really clear picture of the types of divorce, the specific grounds under different personal laws, and the steps involved.
Think of it as a shortcut, maybe. A way to navigate what seems like a really complex process. We'll point out the key differences, maybe some surprising bits, and things you really need to consider in this often misunderstood area of law.
You might have a few aha moments, hopefully.
Hopefully.
Okay, let's unpack this. So when we talk about ending a marriage in India, there's essentially two very different roads you can take, right? It's not just one single process.
That's a really crucial place to start. The article makes a clear distinction between mutual consent divorce and contested divorce.
Okay.
Mutual consent is, well, pretty much what it sounds like. Both spouses agree they want to separate. The source calls this generally the most peaceful and least time-consuming route.
Makes sense.
Yeah, it really does. If everyone's on the same page, you avoid those long, difficult legal fights. There are specific laws for this, like Section 13B of the Hindu Marriage Act, 1955.
Right.
And Section 28 of the Special Marriage Act, 1954. That's the one for interfaith or civil marriages, which is important. And for Christians, it's Section 10A of the Indian Divorce Act, 1869.
So if you both agree, it sounds, well, smoother. But what happens when you don't agree? What's the big hurdle then?
That's where contested divorce comes into the picture. This is when one spouse files against the other based on very specific legal reasons or grounds.
Okay, so one person starts it.
Exactly. And the court has to step in, figure out the facts, and make the decision. It's more than just procedure. It sort of reflects different views on marriage itself, you know? Is it a contract you can end amicably or something that needs serious legal reasons to break?
Interesting distinction.
Yeah, and the choice of path often says a lot about the emotions involved. Critically, the article points out these grounds differ across personal laws, and that's where it gets really fascinating.
Right. This is where India's unique legal setup really shows. The actual reasons you can get divorced change quite a bit depending on your religion. That's not just a small detail, is it?
Oh, not at all. It's fundamental. The legal system is like a mosaic of these personal laws. Your religious identity can genuinely change the legal path available to you.
Wow.
It's quite different from places with totally uniform laws. So under the Hindu Marriage Act of 1955, Section 13 lays out grounds. Common ones are adultery, voluntary sex outside marriage.
Okay.
Then cruelty. This can be physical or mental, but it has to cause a reasonable fear of danger to life or limb.
So, quite serious.
Yes. And desertion. This means one spouse has abandoned the other continuously for at least 2 years without a good reason.
2 years specifically.
Right.
Why that length of time, do you think? And are there other, maybe less obvious grounds under the Hindu Marriage Act people might not know about?
Well, that 2-year period for desertion is likely there to make sure it's not just a temporary spat, but a real prolonged abandonment before you can legally end things.
Right, avoids hasty decisions.
Exactly. And yes, there are some other quite interesting grounds, like conversion, if your spouse stops being a Hindu and converts to another religion. Or unsoundness of mind, meaning incurable unsoundness or mental disorder that makes living together impossible. Another unique one is renunciation of the world.
What does that mean?
It's when a spouse completely gives up worldly life and joins a religious order. It shows how the law connects to historical, even spiritual practices. You wonder how often that comes up now.
Yeah, really.
And then there's presumption of death if a spouse hasn't been heard from for 7 years by people who normally would hear from them.
Okay.
It's also interesting how some grounds have changed. Leprosy used to be a ground, but that's been repealed. And venereal disease is now updated to STDs in communicable form.
That definitely shows the law trying to keep up with society and medicine. And I heard there are some extra grounds just for wives under this act.
That's right. A wife can seek divorce if her husband has another wife living, basically bigamy.
Okay.
Or if the husband has been guilty of rape, sodomy, or bestiality. And another is if the wife married before she was 15, she has the option to repudiate the marriage once she turns 18.
Wow. Okay, so that's the Hindu Marriage Act. But things shift quite a bit from Muslim law, don't they? Different ways to initiate it.
They do. Under Muslim personal law, the husband can initiate talaq, which is traditionally a unilateral declaration. There's also talaq tafwiz, where the right to divorce was sort of delegated to the wife in the marriage contract. And the wife can initiate khula. This is where she seeks divorce, usually involving returning the dower she received at marriage.
Right.
And mubarat is a divorce by mutual consent. Plus, the Dissolution of Muslim Marriages Act of 1939 gives women specific statutory grounds, like cruelty, impotency, the husband failing to provide maintenance, imprisonment, insanity, or if he's disappeared for 4 years.
So quite a few different routes within that framework, too. What about Christian and Parsi laws? Are they similar or very different again?
Under Christian law, which falls under the Indian Divorce Act of 1869, the grounds look somewhat familiar. Adultery, cruelty, desertion for 2 years or more, insanity, conversion, venereal disease. A somewhat unique one there is failure to comply with the decree of restitution of conjugal rights. Basically, if a court orders spouses to live together and one refuses, that refusal can become a ground for divorce later. For Parsi law, under their Marriage and Divorce Act of 1936, the grounds are described as similar to others, things like adultery, cruelty, desertion, unsoundness of mind, and non-consummation of the marriage.
Got it.
And finally, for those civil or interfaith marriages under the Special Marriage Act of 1954, the grounds are generally similar to the Hindu Marriage Act.
So it really does show how the legal system tries to juggle these specific religious traditions with creating a more unified civil option, doesn't it?
It's a constant balancing act, exactly.
So with all these different grounds laid out, the big question is, okay, how does this actually work in practice? When someone decides to move forward, what are the steps in court? Let's walk through that.
Right, let's break down the process. For mutual consent divorce, it starts with a joint petition. Both spouses file this together in the family court.
Okay.
They have to state they've been living separately for at least 1 year.
1 year minimum separation first.
Yes. Then comes the cooling off period. This is usually a minimum of 6 months. It's sort of like the law saying, okay, take some time, think it over one last time.
A final pause.
Pretty much. But, and this is a key point the article mentions, citing the Amardeep Singh v. Harveen Kaur case from 2017, this period can be waived by the court.
Oh, really? When?
If the court believes there's absolutely no chance of reconciliation and waiting would just prolong the agony, basically.
That's a really important insight. It could speed things up considerably if things are truly over.
It can. So after that cooling off period, or if it's waived, if they still want the divorce, they file a second motion. If the court is satisfied everything is in order, it grants the decree of divorce. Marriage over.
Okay. Sounds relatively straightforward if emotionally difficult. Now, what about the contested route? That sounds, well, messier.
It definitely is more complex. For a contested divorce, it starts with one party filing a petition in the family court, stating the grounds. The court then issues a notice to the spouse, the other party, letting them know and summoning them to court.
Okay.
That spouse, the respondent, then files a response, which is their written statement. They might also make counterclaims against the person who filed. You can see how it gets adversarial.
Yeah, back and forth.
Exactly. Then it moves to trial. This involves examination of witnesses and submission of evidence. It's much more like what people imagine a court case to be, presenting proof.
A lot more involved.
Definitely. After all the evidence is in, lawyers make their final arguments to the judge. And finally, the court delivers its judgment. If the grounds are proven, it grants the decree of divorce.
It certainly sounds like a more demanding path. Are there any key things that apply to both kinds of divorce cases, regardless of mutual agreement or not?
Yes, there are several important points. First, jurisdiction. The case generally happens in the family court, where either spouse resides or where the marriage took place.
Okay.
When kids are involved, child custody is always decided based on the best interests of the child. That's the absolute priority.
As it should be.
Absolutely. Then, maintenance and alimony financial support is decided based on factors like the income and conduct of the parties. It aims for fairness.
Right.
And lastly, if one party isn't happy with the family court's decision, they can appeal to the high court, usually within 90 days.
Okay, so there's an appeal process too. Well, we've certainly covered a lot of ground here navigating this complex, but as you said, structured legal process for divorce in India. From those clear differences between mutual consent and contested paths, to the really specific grounds tied to various personal laws, and then the actual steps to get that final decree. We've tried to pull back the curtain a bit.
And understanding these details, especially how the personal religious laws really shape the grounds for divorce, is just crucial if you want to grasp how marriage dissolution works in India. It's tough emotionally, no doubt, but the legal side does aim to provide a clear path.
Right. And as Advocate Jat's article really stresses, understanding the relevant law and procedure is essential. And getting legal advice. Highly recommended to make sure everyone's rights are protected. Definitely not a DIY situation.
Couldn't agree more. You know, thinking about how some grounds have evolved, like getting rid of leprosy as a reason, updating venereal disease to STDs, and the Supreme Court showing flexibility on that cooling off period, it really makes you think, doesn't it?
How so?
Well, how might India's divorce laws keep adapting as society changes, as our understanding, say, of medicine or mental health evolves?
What other grounds might get looked at again? Or how could future court decisions maybe streamline things even more or make the process feel a bit more personalized? It's clearly a system that's still evolving, isn't it?
Yeah.